Well, let's talk for a few minutes about designing your cross-examination. You should be able to look at the record that you're provided with the summary of depositions of the four witnesses, and you'll have a pretty good idea of which facts the other side do not plan to bring out from their witnesses on their direct examination. You need to decide which facts you want to bring out in your cross-examination. And as with direct, make sure you are coordinating carefully with the team member who will be presenting the summation. It's important that the facts be covered so that the discussion on summation can be complete. So let's design the cross-examination. Now, as with direct, I recommend that you start by jotting down in outline form the facts that you have a pretty good idea will not be testified to by the witness for the other side. Take those facts and start writing questions for your cross-examination. Now remember, the time budget is really quite small. Depending on how you allocate time, a cross-examination should be completed in the 5 to 7 minute range. Now, here's a rather subtle but important point for scoring well with the judges. Your job on cross-examination is not to assume or demonstrate that the witness you are crossing has poor motives or has an evil intent of some sort. This can be really quite off-putting to the judges. You merely need to clarify your understanding of the facts. You have a story to tell with your side, and a well-structured cross-examination will take the witness through your story as you want it told. So, in cross-examination, do not expect that you can crowd the witness in some fashion to make a significant admission that will win your case for you. They won't, and neither should you make such an admission under cross. Think of this as simply a fact exercise. You are drawing out on testimony the facts that you will need to argue your factual case and apply applicable law. Okay, so it's not the ultimate question of your case, it's simply eliciting facts from the witness. Now, you must expect some resistance from the witness, and every question you ask must be clearly anchored in the witness's own deposition testimony. If you do not get the answer that you're expecting, if you get resistance of some fashion or wobbling from the witness, then you pull out the deposition and impeach the witness. Here's a bit of impeachment dialogue that might be useful as you prepare. Ms. Witness, let me read what you said in your deposition. I could not walk to the beach that day. The path from the house was completely destroyed by the storm. Do you remember saying that? Is it correct? So let me ask you again, isn't it true that the path to the beach was unusable that day? You see, be prepared to impeach on cross-examination by using the deposition summary that is in the case file. Every fact that you are pulling out of a witness on cross-examination is anchored in the deposition so you can impeach if you get any resistance from the witness. So focus on extracting the key facts on cross-examination, facts that will support your story and also of justifying legally the case that your client is putting forth. Make sure that your partner can use the facts that you are pulling out on cross during the summation, and that's where you will be able to draw the factual conclusions and apply the law to convince the arbitrators of the superiority of your case. So leading questions, as we've described them, are allowed on cross-examination. And here is CAFE's #1 rule on tournament cross-examination. Use only leading questions on cross. No exceptions. A leading question, let's define it, is one that suggests the answer you are after, or one that puts words in the witness's mouth. It's generally is formed to force the witness to answer yes or no to the question. Now, a lot of students will simply use what are called tags to form leading questions. Tags like, isn't that so? Or correct? Or right? Or do you agree? And simply tagging those words to the end of statements that you want to draw the witness out to confirm agreement. I've always thought that there are more interesting ways to form your questions on cross-examination. Something like, would you agree with me that? Or isn't it true that XYZ? Maybe, am I correct in saying that? Or help me understand something. Would you agree with me that? It is simply a little bit less repetitive and more substantive sounding than simply adding tags on to the ends of statements that you want the witness to agree with. Now, many of the same objections that we covered in our discussion of direct examination will apply on cross. The other side will object to a question on cross if it is a compound question, if it's vague, if it assumes facts that are not in evidence, or if it's not relevant. There are a few other objections that you will hear only in response to a cross-examination. Asked and answered is one. This is where the other side is saying, essentially, you've already asked that question, counselor, and the witness has already answered it. Another objection, badgering, argumentative. Here's an example. How do you like this question? Do you expect us to believe that you really felt you had no alternative to canceling the contract? Now, that's simply argumentative and is entirely objectionable. If you ask a question along those lines, fully expect that it will draw objection. Here's another objection that you'll hear on cross-examination. Beyond the scope. Cross-examination is limited to the subjects covered during direct examination. And if you wander beyond the conceptual bounds of the topics that were covered during direct, the question becomes objectionable. Now, it's rarely successful in tournament play, largely because time is just so limited. If you're defending your cross-examination question and you're asking about a topic in the deposition summary, which all parties have agreed to admitting to evidence, simply make that argument to the arbitrator panel and say, I'm simply asking about evidence that was already been stipulated as admissible and in fact has been admitted in this hearing. Tournament rules for the ABA arbitration tournament allow for redirect, but not recross. So you will have an opportunity to ask a couple, maybe 3 questions on redirect that specifically clarify points that might have been confused or somehow manipulated during cross-examination. So limit your redirect to a couple or 3 questions. Now, what about those questions on redirect? They must follow the same format rules as your direct examination questions. Use who, what, where, how, when, and you will be resisting objections to the form of your questions on redirect. It can be very annoying.